Medicaid looks back for 5 years from the date of a Medicaid application to determine if an individual transferred or gave away assets which could have been used to pay for the cost of their care. If they did give away assets during that period, that could trigger a transfer penalty, during which the individual will not be eligible to receive pay for room and board in a nursing facility because they gave away assets which could have been used to pay for the cost of their care. Not every transfer is going to trigger a transfer penalty. If a transfer was made for a purpose other than to qualify for Medicaid, or if the transfer was made to a spouse or to a disabled child, a transfer penalty may not be imposed. The way we determine the transfer penalty actually is we divide the amount of the transfer by the penalty divisor set forth by the Medicaid office. In Indiana this year, that penalty divisor is $5,923. And we divide the amount of the gift by that amount to determine the months and days during which a person would not be eligible for Medicaid because they gave away funds which could have been used to pay for their care. That penalty will not begin running, however, until the individual is in a nursing home and is otherwise Medicaid eligible, but for the transfer they made. So it's important to consult with an elder law attorney to assist you with this process, because you don't want to be in a position where you're in a facility and you need Medicaid eligibility, but you won't qualify because you gave away money and that penalty is only now beginning to run. You want to make sure you can complete a transfer lawfully and have funds to privately pay during any penalty period.